Okay, so we now proceed with the other kind of tort, wrongdoing, trespass to person, assault, and battery, and trespass to land, right? So this kind of type of other tort, so assault, when talking about assault and battery, uh, it is considered as a they are considered as a trespass to persons. So bear in mind that assault and battery can also be a criminal offences. Can be criminal offences. So whereby if a person being assaulted or being being uh, being heated, or battered, so the victim can also make a report to the police. So there will be a if we make a report and then a sue, then there will be a double action. So assault means that an act of a defendant which caused the plaintiff a reasonable apprehension of an immediate infliction of force on him. So whereas a battery is a direct act of a defendant which has the effect of causing contact with the body of the plaintiff without the latter's consent. So the difference between assault and battery is that in assault there is only a reasonable apprehension. A reasonable apprehension mean ketakutan lah, yang munasabah. So without any contact, as compared to battery, of course there is apprehension and there is a contact. So elements of assault example first is some gesture or preparation to commit battery. The threat, and then that the threat must be immediate force. Number two, it must be reasonable fear of harm, and the number three, ability to carry out the threat. Okay. Let's say if somebody show his fish, and that person want to, example, like to punch you, example, that is the gesture with preparation to commit battery, and you will feel fear on that. So of course, if somebody want to punch you in the face, right, and you showing his face, and then there must be a reasonable fear of harm, and that is where must be able to carry out the threat. So that person must be able to carry out that threat. If they want that person want to punch you, then the person must be able to carry out the threat. But if a minor, for example, a boy underage, want to want to punch you, so that is not that person, the possibility the person is able to carry out that threat is can be in questions, can be questions. So it depends on the fact of the case. So battery against, of course, it's not only some gesture, is we call that there must be a contact. If I want to punch you, then I immediately punch you, not just showing that face. So that is battery. So the element of battery, of course, there is a hostile intent, right? There's intention, that the manifestation of that. There must be a manifestation of that, of the threat. Of course, there is a force, right? Not only just a touch, right? If a touch is not, it's not a battery. There must be a force, and the force it's not necessarily injured. It cause an injury to the victim or the plaintiff. It just it needs only a force, the strong force or something like that. It depends lah. And the act must be done by the defendant voluntarily, right? Sometimes uh, that particular act is not done voluntarily, right? By the defendant voluntarily. The defendant might be, example, might be threatened by the other persons. Uh, if you don't punch him, and then I will kill you, example. So that is not considered as a battery. And of course, uh, there is no consent lah. There is no consent of the plaintiff defendant. So if a consent given, especially when there is a example like competition, boxing competition, so the boxer cannot actually sue the opponent, right? Because the nature of that particular sport or particular competition is to punch each other, right? So the plaintiff must not consent of that particular force, right? Other types of trespass, we call it trespass to goods. So trespass to good is defined as a wrongful or direct interference with goods that are in the possession of another. So the element again, mental state of the defendant, intention lah. And the second one is interference. So in this case, let's say you okay relocate some goods, another's goods from one place to another place. So that is also considered as trespass, because it uh, cannot actually interfere other goods. So it's not steal. It's just you take somebody's goods and put to another place. So that is we call as trespass to good. This one, trespass to land, is very common. Trespass to land is very common case, right? Which always happen lah every day, right? So what is trespass to land? Trespass to land, it means unjustifiable intrusions by a person upon the land in the possession of another, right? So in addition, leaving another's land without permission, for example, refusing to leave after permission has been withdrawn, or placing an object upon the land without permission can constitute trespass. Alright, so in the case of trespass to land, right, the action is we call as actionable per se, meaning in order for a plaintiff or the claimant to prove the case, so the plaintiff is just to prove there is only a intrusion by the defendants, by the trespasser, right? So it need not to prove damage upon the land that being trespassed. So that is meaning of trespass. So the proof is just there is a unjustifiable intrusion by the defendant upon the plaintiff land. So the land in this case also include premises like house, shop, or any vacant land. It's not necessary the land, the property itself. It can be a house, it can be a shop lot, it can be a vacant land. Right. So a slight entry upon another's land without permission is sufficient to prove trespass. right? So that is easy, yeah, for the plaintiff to prove his case, right? So it's not necessary that his land is damaged by the defendant, right? Right. Again, in the case of trespass to land, it's not necessary for defendant to prove whether or not that the defendant knows that he is trespassing, the plaintiff land. It is immaterial. It's not. The court doesn't concern whether the defendant knows or not, that the land belong to the plaintiff, right? So there is no such thing that the court take into consideration the mental what you call it, the mental state of the defendant. eh? Right. In relation to the trespass to land again, right? Uh, what is necessary for the plaintiff to prove again that the land actually is not it's not necessary for the plaintiff to prove that he owns that land. Meaning to say, the land not necessary that the land belong to him. Eh? It's just sufficient for the plaintiff to prove that he possesses the right. In proving the trespass, right? Again, apart from that, it's just sufficient for the plaintiff to prove that there is unjustifiable instructions. The the plaintiff also is sufficient to prove that he or he possesses that kind of land. It's not necessary that he has to prove that the land is owned by him. To say there is no need for the plaintiff to prove ownership, ownership over the land. That's why in the case of temporary occupation license or toll, right, TOL. So TOL it doesn't own the land, so it's just a tenant, who who got a license from the government. So, but the court, even though he just a temporary occupation, the law considers that toll holder has exclusive possession of a premise. I'm sorry, though he's not a landlord, as compared uh, to the hotel lodger, or hotel guest. So hotel guest doesn't possess exclusive possessions. So we need to say if there is somebody trespass or enters into your hotel rooms. So you cannot sue the trespasser under the trespass. But for the toll holder, so the law give the exclusive possession of the as toll holder, and if somebody trespass the land, then the toll holder can sue that the trespasser. So in the case of so this is proven in the case of Yulaika Bibi and Maidin. The court held that the court recognized the entitlement of a fresh toll holder to bring an action of ejectment against the tenant of the previous toll holder that had been withdrawn his license. So this is clear case that a toll holder can sue the trespasser, right? So, but in this case, the new toll holder sued the previous toll holder which has been withdrawn his license. The license has been expired, meaning to say he has no longer has the rights to occupy the land. So the new toll holder can bring action for ejectment. Right. So apart from trespass to land, we have a trespass to highway, right? Highway doesn't mean it's a plus highway. It, it, it can also means road. If there is a road in your land, so that is considered as trespass to road or trespass to highway. So the case of Hickman and Macy, right? So when there is arresting Tort held by the court as a trespasser when he had been walking up and down a 15-yard stretch of the highway to watch the take notes of the trial of his of racehorses going on in the plaintiff land. I mean to say, if you are not allowed to enter others' land, others' land which the road uh, in that particular land, so we cannot just pass by that particular road. So it's considered as trespass to also land lah. Trespass to highway, trespass to roads, and that. Second one is trespass to subsoil. So we need to say, apart from the land, so we have a subsoil under the land. So in the case of land, we cannot trespass another's land from the land itself up to the sky. Of course, there's a limit up to the sky, and also the down to earth. So that is the principle of the ownership or possession of the land. Possession of the land. So in the case of Tarupanan and Balakrishnan, it is illustrated that the fact that the appellant bought a hotel whose sewage system or manhole and septic tank encroached on the respondent's land, so it's considered also trespass. So in this case, the owner is entitled to an interlocutory mandatory injunction to remove the source of the trespass. The sewage system and manhole, septic tank itself has encroached the respondent's land. That's why the court gave the interlocutory mandatory injunction to remove that particular septic tanks and manholes that trespass to the subsoil of the appellant's the respondent land. So meaning to say, in this case, is a appellant in this case is the defendant. Previously, he was a defendant, and respondent is a plaintiff, of course. So we need to say the appellant actually the respondent has won the case during the high courts levels, and then the defendant become appellant, appeal to the higher courts. Okay, the next is trespass to airspace. So we have the land, highway, subsoil, and the last is a trespass to airspace. So of course, when talking about airspace, there is a limit. We can enjoy the airspace of our land to some limits. If not, the aeroplane cannot pass by our land. So you sue Mars, you will sue AirAsia for trespassing the land. Otherwise, So for trespass to airspace, section 44(1)(a) for the Malaysian National Line Code, owner of the land exclusive use of so much airspace is reasonably necessary to the lawful use and enjoyment of land. Right. So we can only enjoy our airspace reasonably necessary, as reasonable as we can enjoy lah. So we need to say we have to actually allow aeroplane to pass by our land, airspace. But what is reasonable? We call limit for airspace is restricted in the case of Carlson and Perel Tobacco, where the court held that an advertising sign erected by the defendants on their own property, which projected into their airspace above the plaintiff shop, created a trespass. So the plaintiff can bring an action for injunction even if he suffers no damage at all. So same goes to if you have, for example, a tree, for example, which the branches of the tree actually goes beyond the your neighbor's land, so that is also considered as a trespass. Okay, for as far as the defenses are concerned, defenses mean what kind of in some circumstances whereby some the law actually permits the so-called not trespasser lah, officers something like that to perform their job, to perform their duties, right? So sometimes they need to to enter the premise, others' premise, for the sake of performing their duties. Let's say under section 16, subsection 1 of the Malaysian Criminal Procedure Code give power to any person acting under warrant. If you have warrant of arrest or any police officer or penghulu having authority to arrest, the authority to search a place entered by a person they intend to arrest. If you have mean to say a police officer has a warrant to arrest a person, so they can actually enter the premise without a permissions. So again, for the sake of preventing other persons or arrest person to escape from that premise, so they can break out the doors or something to that particular premise. So other officer like a bailiff also. A bailiff is a officer of the court. So a bailiff can also enter private premises, but it cannot breaking. Cannot break the property, the premise. If the door can open, then he just can open up the door and then give that notice. Actually, a bailiff, one of the job of the bailiff is give a notice, notice of calling for actually debt, debt. Okay, hutang, minta hutang. Number 2, license. A license is permission given by a licensor to licensee to enter into stay in new land for a period of time. This can be made. Okay, this is example like a toll holder lah. We have discussed already, right? So toll holder is given license to live in a portion of land for a certain period of time. So upon the expiry of that time, so he's considered as trespasser. If he doesn't actually vacate the land, he has to to leave the land. Otherwise, he is also considered as trespasser. Okay, in terms of remedies, right? So for remedies, there are some type of remedies for under the especially for the trespass, right? One is damages. Okay, in terms of the remedies, we have damages and injunction. Uh, so damages is in the form of monetary compensations. Let's say in trespass to land, the owner can actually sue for monetary damages. Sue for the monetary damages. But sometimes the trespasser actually does the trespass. There is a recurring, continuing trespass over the land, then the court will order the injunctions. If the damages is not sufficient, the court will order injunction. So if the defendant refuse to follow the court's order, so there will be a contempt of court. There will be a contempt of court. So when talking about contempt of court, the defendant can be imprisoned. Imprisoned by court. Okay. Alright. So I think that's all for the law of tort. Thank you very much. If there is a question, then we will discuss in the class. Thank you.